Mr. Lakitu, waiting patiently. Thank you.
Thank you, Mr. Chairman. I'm glad that this morning as I was reviewing this, I reduced my 47 slides down to 5. My name is Peter Lakitu. I'm a partner at Robinson Kohl in Providence. I've been practicing law in Providence for, I think it's over 45 years now. For much of the last 30 years of that, I've been representing Narragansett Electric, now National Grid, in siting cases. I appreciate the opportunity to address you at the suggestion of Dr. Bianco and the invitation of the chair. I am presenting my own opinions, and I'm not speaking on behalf of National Grid today. I would like to share some of my experiences in permitting mostly transmission lines and associated facilities. And what I thought would be useful is just to go through 4 slides, show you some examples of some of the major projects that we have permitted for National Grid. The first is a Southern Rhode Island transmission project, which we filed with the siting board in 2005. The project, I believe, was in the neighborhood of 20 miles end to end. There were a number of different components to the project. It started in Warwick at the Kent County substation, which you see off 95 as you drive south before you hit Route 4. It went south through East Greenwich, North Kingstown, Exeter, South Kingstown, and Charlestown. So that project went through 6 cities and towns in the state. The next example is the Rhode Island Reliability Project. This is the project that's out parallel to the 295 corridor. We filed this project in 2008. It involved adding a 345,000 volt transmission line to that existing right-of-way. And in order to do that, it was necessary to rebuild 2 existing 115,000 volt transmission lines in the right-of-way. In that case, the project started up in North Smithfield at the West Farnham substation. It ran south through North Smithfield, Johnston, Cranston, West Warwick, and Warwick. I will say that Mr. McElroy must have been involved with other cases than I have when he said that generally transmission lines are supported by the towns. North Smithfield and Smithfield were nice to us. Johnston and West Warwick gave us a real argument in that case, and in the prior case, I believe North Kingstown was probably the biggest opposition. But in both of those cases, we had serious opposition. So the projects, my feeling is when there's serious opposition, the projects get aired out to the extent that the opposition hires and brings in brings in experts. It's a better opportunity for the siting board to see both sides of the case and make a good decision. The third project is a 2012 project, the Interstate Reliability Project. This project was about 25 miles in Rhode Island. You see the yellow line on the upper right-hand corner of the map. The line came down through Uxbridge into Rhode Island, into North Smithfield to the West Farnham substation, and then from there it turned west and ran generally westerly through North Smithfield and Burrillville on the existing right-of-way and into Connecticut. And this was a major project involving all 3 states to increase the reliability of the electrical system. Again, 25 miles or so in North Smithfield and Burrillville. And my recollection, it was 45 miles or more overall among the 3 states. The fourth project is the Aquidneck Island Reliability Project, which is one we filed in 2016 and just recently finished. It connected an existing substation in Portsmouth at the north of the plan you have before you, went south through Portsmouth into Middletown to a new substation that was proposed in Middletown. Again, in that case, we had some spirited opposition, if I may say so. We've handled a number of other projects before the siting board. Some of them, I guess none of them as significant as these projects, but other projects, some of them were tap line projects, which are small interconnections from an existing transmission line into a substation. As you can tell from most of those maps, the point of a transmission line project often is to connect point A to point B. There are a fairly limited number of alternatives to accomplish that. I will say that I think the concept behind the Siting Act when it was first being considered in the 1980s was to come up with a one-stop licensing process. So somebody proposing a project would go to one agency and go through the whole process and get the permit or not get the permit. From the utilities standpoint, it is not a one-stop process. As Mr. McElroy and his colleague explained, there are many stops in this process. I do believe the enactment of the Siting Act in 1986 was recognition by the General Assembly that energy projects do have statewide importance. And if you're going to give each municipality, I mean, if you look back at, let me see if I can get back. Nope, I can't. Okay. Anyway, if you look at some of those couple of projects I showed that went through 6 cities or towns, if you gave any one of those municipalities the right to veto it, we'd never build anything. So, you know, there may be some that feel that's a good outcome, but we want to be able to charge our phones and we want our hot tubs warm. So, my colleagues have been through the process. I was going to run through the process briefly with you. I will make a couple of comments about things that they said. One related to confidential information. Obviously, the case they're involved in, the Invenergy case, is a different case, a different situation than from what I've been doing with transmission lines. The only confidential information that we get into with transmission lines is something we call CEII, which stands for Critical Energy Infrastructure Information. And this is something that FERC has required utilities to protect ever since 9/11. They don't want us giving plans for major facilities that would enable a terrorist to focus on a facility. So to the extent that we have information in some of our supporting reports that is considered CEII, then we redact that and provide it only under seal to the siting board and other parties who sign the non-disclosure agreements. There was a lot of talk about the advisory opinions. It's a very important process, and what the Siting Act basically says is that the agencies that are asked to give an advisory opinion go off and do the process as they would if there wasn't a Siting Act. So in Zoning cases, if we need zoning relief, we file the zoning application, we go before the zoning board and put on our case before the zoning board. I will say that I think every case that I've been involved in, every full siting case, the siting board has asked for zoning opinions or advisory opinions from the zoning boards. They've asked for advisory opinions from the planning boards in the affected communities. They've asked for advisory opinions from building inspectors in the affected communities, including an opinion as to whether the project is in compliance with local ordinances. They ask Health Department. They ask the Public Utilities Commission to provide an opinion on the need and the alternatives. And I'm sure I'm missing a couple that Dr. Bianco could provide, but I'm not aware of any situation in which somebody has said you should ask the such and such planning board for an opinion, and the board said, no, we're not going to do so. They've been very expansive in my experience. The public input hearings, again, our experience has been different, apparently, from what Burrillville has experienced in the proceeding. We generally try and, I'm a copious note taker. I don't know if anybody saw me here earlier, but writing and writing and writing. And what we do is we take notes during the public input hearing, and at the end of the hearing, we start the hearing off with a presentation by the company, an overview of the project. Then there's public input, and I'll say we do a very brief overview just to sort of get everybody on the same page. And then we take the public input, the siting board takes the public input, and we ask the siting board for time to respond to questions and comments to the extent it's appropriate. Now, sometimes if it's 11 o'clock or so, the siting board may not turn to us and say, okay, spend another hour or two responding, but in many cases we have provided responses to the siting board. The final hearings that the siting board holds are the hearings where all the parties bring their experts in. As Mr. McElroy said, there's pre-filed testimony, which takes out some of the suspense that you might have in true litigation, where you may or may not know what the witness is going to say. But it really, again, allows the siting board to focus on the technical issues and make a decision based on the technical evidence presented before it. Overall, this is a 12 to 15 to 18-month process before the siting board. It's a very rigorous process. I believe it was Mr. McElroy identified the 3 members of the board, chair of the PUC, currently Margaret Curran, the director of DEM, currently Janet Coit, and the associate director of administration for planning, Parag Agarwal. I'm sorry, I have a terrible time with his name. The siting board sits as an impartial, quasi-judicial body. They're charged with hearing and deciding the cases on the evidence before them. It's something that judges do every day, as those of you who spend any time in court.
Well, but Peter, isn't it true that judges have lifetime tenure?
Most judges do
In Rhode
have
Island?
lifetime tenure, yes.
That may not be the case for members of the siting board, isn't that correct?
I suspect that none of them would want lifetime tenure.
That's a good answer.
But they are charged with making a decision on the record based on the evidence in front of them, and there is an appeal process for parties that are unhappy with or object to the decision. I think the service on the siting board is a I won't say it's a burden, it's an additional duty for these three individuals, all of whom have very serious, time-consuming state jobs, full-time jobs. Dr. Bianco can confirm this, but my observation, I think Mr. McElroy actually can confirm it. My observation is that one of the major issues the siting board has is scheduling. You've got to get three people with many other commitments together for multiple days of hearings, and I'm not sure that expanding the size of the siting board, adding more people to it, is going to make that any easier. So, I share the concern that several of you expressed about the impartiality. I had a couple of other comments. In terms of the discussion of the environmental impact statement, environmental impact document, I know that was undertaken in the Manchester Street project, which was one of the first, I guess it was the first siting project that I handled. That was a case where we filed the application and there was no opposition. And so I think the board at the time felt that they wanted to go through this process and make sure, again, that the issues were aired out and that they made a good decision. One problem with adopting a NEPA type EIS process is that the General Assembly has cut out two big pieces of environmental consideration from what the siting board looks at. The siting board doesn't have jurisdiction over the DEM issues, and it doesn't have jurisdiction over coastal resources. So I don't know how you can do a comprehensive environmental review of a project if you don't have those pieces as part of the process. There was also some discussion about what happens if an agency finds that it can't issue an advisory opinion in time. In one proceeding, the siting board asked everybody to get the advisory opinions completed, all the agencies to get them completed within 4 months. And I forget what the circumstances were, but the Public Utilities Commission came back very quickly and said, our process is going to take more than that. We need 6. And so the board said, okay, we'll give everybody 6 months. In another case, because of a resignation of one of the members of the Public Utilities Commission, the commission didn't have a quorum. And so they wrote a letter to the siting board and said, I'm sorry, we don't have a quorum. Here's the case back. You, the siting board, can consider the need issue, which the siting board did in that case. So there are ways that the agencies make adjustments. In that case, the Public Utilities Commission, the question of need and cost were considered by the siting board in its final hearings. I guess the other thing that struck me in the presentation was some of the communications suggestions. I think it's good to expand the communications. National Grid has made a real effort in its projects to do outreach before they file. They don't want the neighbors to read about it in the paper and then call the council president and give him a bad time about it. They want everybody to know what's out there and what's coming before they file. It doesn't always resolve all the issues, but at least it cuts down the number of surprises, and I suspect the late night calls that council president might otherwise receive. I think that pretty much summarizes what I had to say. I'm happy to answer questions.
Peter, do you, you obviously have extensive experience in front of the Rhode Island Energy. Have you practiced in other states as well?
I have not. No, I'm a member of the Rhode Island Bar and Rhode Island Bar only.
Mr. Rosselli.
Mr. Lakitu, thank you. Thank you for your presentation and information. I think it might be helpful for the folks who are watching this and also for the board to understand a little bit, way back 31 years ago, what the industry was like. What was the power industry like 31 years ago? And do you think that had any influence on how the EFSB was created or put together? Because it was a different industry 31 years ago.
31 years ago, before that was before the industry was deregulated, and the generation, at that point, the utility, the electric utilities were really end-to-end. It was generation, transmission, distribution, the whole thing. In terms of how that, the major change is that the PUC doesn't really know what to do with the question of the reasonableness of cost. I'm sorry. I think the PUC has struggled with how to handle the question of, is the cost reasonable? Will the cost of the power be reasonable? Because it all goes through the ISO process now, and it's not a question of the cost of the generating plant being put in the utilities rate base and charged to ratepayers over the next 40 years. So it's changed. The industry has really changed. I'm not sure, with the exception of the PUC issue, that it's made a great deal of difference in the siting process.
But if
Go
I
ahead,
may,
Paul.
Mr. Chairman, but I'm glad you mentioned that. So way back when, as you say, the industry was pretty much, you had a power company, they produced it, they put up the lines, they got it to your home. And you could easily come up with, here's how much it cost, here's how much you're going to pay for it. There was a straight line there. Now with deregulation, and we're experiencing that in this particular case, and I'm sure others as well, we're experiencing, because of that deregulation, that there's no clear line, there's no straight arrow between the production of it, or maybe there is, and if there is, please correct me, but there doesn't appear to be any straight line between the production of electricity, in this case, and the transmission and the distribution and then the transmission of electricity to the ratepayers. Am I characterizing that pretty well, or
I don't know that when you say there's no straight line, I mean, it's not one entity that's doing it. It used to be that Narragansett Electric owned the generating plant, and they owned the transmission lines, and they owned the distribution lines in Rhode Island. Now you have third parties owning the generating plants. They bid into the ISO system, the ISO process. I'm
not trying to put you on the spot or anything. Trust me, I'm just trying to make the distinction that 31 years ago was a different industry, and 31 years hence, here we are with, as you say, third parties, ISO New England, pretty much flicking switches on and off to actually make sure that the lights stay on, and then folks like National Grid actually involved in making sure that the lines are up and the crews are out there doing their thing, no matter what they do. But I want to make the distinction between those two, because that was 31 years ago. So in your mind, we're essentially looking at an EFSB that was created and still is in that 31 years mode.
That's true. It was created 31 years ago. There are different members on the siting board than there were 31 years ago.
I would hope so.
I don't know that that is a big difference. I mean, certainly for transmission lines, it's the same process we followed 28 years ago when I did my first transmission case. When we did, or I don't know how many years ago it was, but I mean, it's basically the same process. It's the same issues, the same process. So I'm not sure that the passage of time really has changed things that much.
If there were a magic wand that if you were czar, as I've heard other people mention that they wish they were, if you were, is there anything on the EFSB that you would modify, given your experience with
That's a
them?
good question. I'd really have to
Good answer.
step back and look at
I would love to have an answer at some point,
that.
please.
Yeah. Let me get back to you on that if I could.
Of course.
Thank you.
Dr.
Thank you,
Bianco?
Mr. Chairman.
Mr. Lakitu, did you mention you worked on the Manchester Street application?
Yes, I did.
And that was then part of a vertically integrated public utility?
Yes, that was Narragansett and New England Power that were the co-owners of the project.
And just to sort of play off Mr. Roselli's, but the others that you're aware of, the other applications that have come through, those were merchant generators?
Yes, Tiverton. I did sit in on some of the early Tiverton hearings. I don't know if Pawtucket Power, I don't think that went through the siting board. I think maybe it was below the threshold. The Johnston, the Rhode Island, I forget the name of it.
Rhode Island State Energy Project? Or the
Rise,
yeah.
that's it. Ocean State, I think, was probably the first. So other than Manchester Street, they've all, really, Ocean State was before Manchester Street. So there's a merchant plant that was in the very early days.
Mr. Daniels?
This is a question for Mr. Lakitu, or maybe the panel overall. What is the EFSB's responsibility after the project is completed? So it looks under the statute that there's the opportunity for violations, but how much continuity is there in following a project after implementation? Have there been violations cited in the last few years? What's the follow-up from the board?
I'm not aware that there have been any violations. The siting board has a provision late in its, towards the end of its rules for the appointment of somebody to be sort of the eyes and ears of the siting board in connection with the construction of a project. And I think this was mostly related to power plant projects. I think that was really the focus. I'm sorry Mr. Gray's left, because I think that most of the enforcement post-construction, once the plant goes into operation, are the environmental issues, air issue, water, that DEM would enforce.
The reason I ask is that if we're talking about changing the membership of the board dependent on the project or the location, then that might be problematic if there's an expectation that that board is going to be working on oversight of a project. But if it seems that when that project is essentially done, then the group can change, then it wouldn't be as big of a deal.
I suppose whatever the makeup of the board is, it could enforce the board's prior orders. I guess when you talk about adding people to the board, I think there's a real issue about the impartiality. I mean, I can't imagine that you could find, there are just so many strong feelings in municipalities about these projects, that it's, I don't know how you add somebody on and expect them to be impartial. I think somebody pointed out that they were likely to be the subject of a lot of comment from their neighbors, and I think the other issue, Ms. Donaldson mentioned that with the open meeting law, any discussions would have to be in the open. Well, if you had 5 people on the board, then the 2 public members could go sit in the corner and talk by themselves, and it wouldn't all be out in public. So, I think the open meeting requirement is a burden on the siting board and on the Public Utilities Commission, but by the same token, it's fresh air, and fresh air is good. So I remember when that ruling was made by Denny Roberts many years ago that said that the PUC had to deliberate in public. So be it.
Paul?
In thinking about 31 years ago, I was certainly a lot younger then, and I suspect all of you were too. In fact, I'm positive you were. One of the things that also changed in that 31 years is the makeup of state agencies, and this is both a comment and a question. The question is what has the impact been? For example, in 1986, DEM had about 600 people on staff. Today, they're just pushing 400, and there are calls now for more reductions. So how can we expect? And that was the rhetorical part. But I'll just put the question out there: Have you seen any? And Mr. McElroy, Mr. Lakitu, have you seen any impact over the years from a reduction of particularly DEM staff going from 600 now down to less than 400? From the standpoint of citing cases, DEM was very active in the Manchester Street project, as I recall. I think from time to time they've been asked for advisory opinions in the transmission line cases, but I'm not sure I can recall any times when they gave advisory opinions. They have their own jurisdiction. They have the wetlands jurisdiction. They have air and water jurisdiction. Coastal Resources has its jurisdiction. So they're really going to handle that through their process rather than coming in and basically trying the case twice. So, one agency I forgot to mention that always gets asked for an advisory opinion is statewide planning. And they take it very seriously. They put their staff on it. The staff does a report, which they take to the State Planning Council. If we get notice of it, we will often go in and make a presentation to the State Planning Council. But it's another way in which the issues get aired out for the various agencies.
My experience has been that DEM is very thorough, and I haven't seen any change based on staffing. The decisions they render are thought out and detailed, both within their statutory jurisdiction, as Peter pointed out, as well as if they're asked an additional question by the board.
I'm more curious about time and like how long. I know there are certain authorities, they have to render advisory opinions within a certain time period. Have you seen over the years any
I have not
change
seen
in that?
DEM, in my cases, asking for more time.
I think if the gentlemen in the second row up here would provide more funding for DEM, I'm sure they'd be very happy with that. Is that what you're suggesting, Mr. Roselli?
That's certainly one of the
I just wanted to make
suggestions,
sure
yes.
that-
Absolutely. Thank you.
Mr. Olkowski?
Thank you, Chair. Mr.
Lakitu.
Lakitu, thank you. So you mentioned earlier, I think you made this statement, and I'm paraphrasing, I don't want to quote you incorrectly. When opponents are involved in the process and hire an attorney, there's a better opportunity to review the project and air it out. Could you explain that a bit in terms of why that improves the process from your perspective?
Maybe I shouldn't say improves the process. I think it'd be much easier for me if there wasn't opposition, for me representing a client. But I think that...
Just pretend and put that aside for a moment.
In any proceeding, in any legal proceeding, whether it's a quasi-judicial, such as a siting board, or the Public Utilities Commission, or a court hearing, if you've got both sides being presented to the decision-making authority, you're probably going to get a better decision. It's going to raise issues. It's going to, as I said a couple of times, air it out. I think it really it's likely to bring forward the obviously the two sides and their positions, and presumably the board will make the best decision.
So I think a key word in there is higher, right? So, you know, in those instances where, you know, you have, you know, communities or, you know, communities that are maybe disproportionately affected, and maybe can't hire attorneys. You know, I think we batted this idea around about a public counsel that could represent them. It sounds like, you know, you feel like that the airing out of that is beneficial overall to the process and to transparency. But in many cases, you know, maybe it can't be afforded. Would you be supportive of a change that built that into the process?
You know, I don't want to take a position on that. I think in as I think back over the cases in the situation, cases I've been involved with, if the municipality has been concerned about it, sometimes they get their city or town solicitor involved in the first instance, but it evolves and they end up with another lawyer that's representing them. So I think they've been able to do it. They've been able to get representation and present a case.
Yeah, I'm thinking about it from an environmental justice perspective, but, you know, so your position is they've normally been able to arrange counsel and be represented and be a part of the process?
I think so, yes.
Thank you.
Certainly.
Paul?
Thank you. The Borough Land Trust has certainly been a beneficiary of some of the work of National Grid, particularly during the Interstate Reliability Project. And one of the things that I wanted to echo and make sure we stress is this idea of open communications, all during that process. And I want to spend a little bit of time just illustrating just what that process looked like. There was a liaison that the town and the land trust and all of the conservation organizations along that corridor from the western part of Rhode Island to the northern part of Rhode Island. We had a liaison for that individual, for that project. We had a direct number to someone at National Grid. We had access to people at the Army Corps of Engineers as well as FERC. So if there were any questions, it was an easy access. It was easy. What's our experience lately is that it's not so easy. Whether it be this project or other projects, not with National Grid, but with some of the third-party folks, and certainly with this project that's going on the northwest corner of Rhode Island. It's not an easy communication process. Communications get skewed, or the wrong date or the wrong location is on particular pieces of collateral information. But for that particular project, the one thing that stood out for me and many people who were involved was the open communications, the easy access. And whatever we do here, Mr. Chairman, and certainly our panel today, that's going to be key. We have to open up this communications process much greater than it has been. And if you're looking for a model, and please excuse me for saying this, but it's true. If you're looking for a model, look at what National Grid did with this last project. Thank you, Mr. Chairman.
Could I just follow up on that?
By all means, Peter.
I will thank you, Mr. Roselli. I'll take that comment back, and I think they'll be happy to hear it. But as I said, I think National Grid has put a real premium on outreach, both initially and then during the permitting process. And then once a project's approved, they've got a team that I know on the Interstate Project and the Rhode Island Reliability Project put out a newsletter every 2 weeks. And all you had to do is put your hand up and send them your email address, and you'd get this newsletter every 2 weeks, and it would say where they're working and what they're doing and any news about the project and where they're going next. So there really was I think, very good communication. Having said that, I don't know how you mandate that. I mean, it seems to me that either a project proponent's going to do it or they're not going to do it. And I'm not sure how you write that into law that says you got to do what National Grid did.
I can write it.
Okay, fine. Thank you. Thank you, Mr. Chairman.
Any further questions? Okay, thank you very much. Our next meeting is going to be on Monday, December 18th at 3 o'clock. It'll be back in this room. And at that meeting, we're going to take public testimony. And it won't be the only hearing we take public testimony. I think we'll do one more. But this will give the public an opportunity to come and let us know what they think should be changed about the Energy Facilities Siting Act. And thank you all very much for being here. The three of you, I think, were all very helpful to the committee. I certainly appreciate it. And I appreciate all the members of the committee who come from all walks of life, taking time out of your very busy schedules to come here to the State House and listen to this important issue. So thank you very much, and we'll see you on the 18th. Can I have a motion to adjourn? So moved. And a second. All in favor? Aye. We are adjourned.